International Covenant on Civil and Political Rights, General Comment Number 13, Administration of Justice. 1. The Committee notes that Article 14 of the Covenant is of a complex nature and that different aspects of its provisions will need specific comments. All of these provisions are aimed at ensuring the proper administration of justice, and to this end uphold a series of individual rights such as equality before the courts and tribunals and the right to a fair and public hearing by a competent, independent and impartial tribunal established by law. Not all reports provided details on the legislative or other measures adopted specifically to implement each of the provisions of Article 14. 2. In general, the reports of states parties fail to recognize that Article 14 applies not only to procedures for the determination of criminal charges against individuals but also to procedures to determine their rights and obligations in a suit at law. Laws and practices dealing with these matters vary widely from state to state. This diversity makes it all the more necessary for states parties to provide all relevant information and to explain in greater detail how the concepts of criminal charge and rights and obligations in a suit at law are interpreted in relation to their respective legal systems. 3. The committee would find it useful if, in their future reports, states parties could provide more detailed information on the steps taken to ensure that equality before the courts, including equal access to courts, fair and public hearings, and competence, impartiality and independence of the judiciary are established by law and guaranteed in practice. In particular, states parties should specify the relevant constitutional and legislative texts which provide for the establishment of the courts and ensure that they are independent, impartial and competent, in particular with regard to the manner in which judges are appointed, the qualifications for appointment, and the duration of their terms of office, the condition governing promotion, transfer and cessation of their functions, and the actual independence of the judiciary from the executive branch and the legislative. 4. The provisions of Article 14 apply to all courts and tribunals within the scope of that article, whether ordinary or specialized. The committee notes the existence, in many countries, of military or special courts which try civilians. This could present serious problems as far as the equitable, impartial and independent administration of justice is concerned. Quite often, the reason for the establishment of such courts is to enable exceptional procedures to be applied which do not comply with normal standards of justice. While the Covenant does not prohibit such categories of courts, nevertheless, the conditions which it lays down clearly indicate that the trying of civilians by such courts should be very exceptional and take place under conditions which genuinely afford the full guarantees stipulated in Article 14. The committee has noted a serious lack of information in this regard in the reports of some states parties whose judicial institutions include such courts for the trying of civilians. In some countries, such military and special courts do not afford the strict guarantees of the proper administration of justice in accordance with the requirements of Article 14, which are essential for the effective protection of human rights. If states parties decide in circumstances of a public emergency as contemplated by Article 4 to derogate from normal procedures required under Article 14, they should ensure that such derogations do not exceed those strictly required by the exigencies of the actual situation, and respect the other conditions in paragraph 1 of Article 14. 5. The second sentence of Article 14, paragraph 1, provides that everyone shall be entitled to a fair and public hearing. Paragraph 3 of the article elaborates on the requirements of a fair hearing in regard to the determination of criminal charges. However, the requirements of paragraph 3 are minimum guarantees, the observance of which is not always sufficient to ensure the fairness of a hearing as required by paragraph 1. 6. The publicity of hearings is an important safeguard in the interest of the individual and of society at large. At the same time, Article 14, Paragraph 1, acknowledges that courts have the power to exclude all or part of the public for reasons spelt out in that paragraph. It should be noted that, apart from such exceptional circumstances, the committee considers that a hearing must be open to the public in general, including members of the press, and must not, for instance, be limited only to a particular category of persons. It should be noted that, even in cases in which the public is excluded from the trial, the judgment must, with certain strictly defined exceptions, be made public. 7. The committee has noted a lack of information regarding Article 14, Paragraph 2 and, in some cases, has even observed that the presumption of innocence, which is fundamental to the protection of human rights, is expressed in very ambiguous terms or entails conditions which render it ineffective. By reason of the presumption of innocence, the burden of proof of the charge is on the prosecution and the accused has the benefit of doubt. No guilt can be presumed until the charge has been proved beyond reasonable doubt. Further, the presumption of innocence implies a right to be treated in accordance with this principle. It is, therefore, a duty for all public authorities to refrain from prejudging the outcome of a trial. 8. Among the minimum guarantees in criminal proceedings prescribed by Paragraph 3, the first concerns the right of everyone to be informed in a language which he understands of the charge against him, subpara a. The committee notes that state reports often do not explain how this right is respected and ensured. Article 14, 3a, applies to all cases of criminal charges, including those of persons not in detention. The committee notes further that the right to be informed of the charge promptly requires that information is given in the manner described as soon as the charge is first made by a competent authority. In the opinion of the committee, this right must arise when in the course of an investigation a court or an authority of the prosecution decides to take procedural steps against a person suspected of a crime or publicly names him as such. The specific requirements of subparagraph 3a may be met by stating the charge either orally or in writing, provided that the information indicates both the law and the alleged facts on which it is based. 9. Subparagraph 3b provides that the accused must have adequate time and facilities for the preparation of his defense and to communicate with counsel of his own choosing. What is adequate time depends on the circumstances of each case. But the facilities must include access to documents and other evidence which the accused requires to prepare his case, as well as the opportunity to engage and communicate with counsel. When the accused does not want to defend himself in person or request a person or an association of his choice, he should be able to have recourse to a lawyer. Furthermore, this subparagraph requires counsel to communicate with the accused in conditions giving full respect for the confidentiality of their communications. Lawyers should be able to counsel and to represent their clients in accordance with their established professional standards and judgment without any restrictions, influences, pressures or undue interference from any quarter. 10. Subparagraph 3c provides that the accused shall be tried without undue delay. This guarantee relates not only to the time by which a trial should commence, but also the time by which it should end and judgment be rendered. All stages must take place without undue delay. To make this right effective, a procedure must be available in order to ensure that the trial will proceed without undue delay, both in first instance and on appeal. 11. Not all reports have dealt with all aspects of the right of defense as defined in subparagraph 3d. The committee has not always received sufficient information concerning the protection of the right of the accused to be present during the determination of any charge against him, nor how the legal system assures his right either to defend himself in person or to be assisted by counsel of his own choosing, or what arrangements are made if a person does not have sufficient means to pay for legal assistance. The accused or his lawyer must have the right to act diligently and fearlessly in pursuing all available defenses, and the right to challenge the conduct of the case if they believe it to be unfair. When exceptionally for justified reasons trials in absentia are held, strict observance of the rights of the defense is all the more necessary. 12. Subparagraph 3, e, states that the accused shall be entitled to examine or have examined the witnesses against him and to obtain the attendance and examination of witnesses on his behalf under the same conditions as witnesses against him. This provision is designed to guarantee to the accused the same legal powers of compelling the attendance of witnesses and of examining or cross-examining any witnesses as are available to the prosecution. 13. Subparagraph 3, f, provides that if the accused cannot understand or speak the language used in court, he is entitled to the assistance of an interpreter free of any charge. This right is independent of the outcome of the proceedings and applies to aliens as well as to nationals. It is of basic importance in cases in which ignorance of the language used by a court or difficulty in understanding may constitute a major obstacle to the right of defense. 14. Subparagraph 3, g, provides that the accused may not be compelled to testify against himself or to confess guilt. In considering this safeguard, the provisions of Article 7 and Article 10, Paragraph 1, should be borne in mind. In order to compel the accused to confess or to testify against himself, frequently methods which violate these provisions are used. The law should require that evidence provided by means of such methods or any other form of compulsion is wholly unacceptable. 15. In order to safeguard the rights of the accused under paragraphs 1 and 3 of Article 14, judges should have authority to consider any allegations made of violations of the rights of the accused during any stage of the prosecution. 16. Article 14, Paragraph 4, provides that in the case of juvenile persons, the procedure shall be such as will take account of their age and the desirability of promoting their rehabilitation. Not many reports have furnished sufficient information concerning such relevant matters as the minimum age at which a juvenile may be charged with a criminal offense, the maximum age at which a person is still considered to be a juvenile, the existence of special courts and procedures, the laws governing procedures against juveniles, and how all these special arrangements for juveniles take account of the desirability of promoting their rehabilitation. Juveniles are to enjoy at least the same guarantees and protection as are accorded to adults under Article 14. 17. Article 14, Paragraph 5, provides that everyone convicted of a crime shall have the right to his conviction and sentence being reviewed by a higher tribunal according to law. Particular attention is drawn to the other language versions of the word crime, infraction, delito, Prestupellini, which show that the guarantee is not confined only to the most serious offenses. In this connection, not enough information has been provided concerning the procedures of appeal, in particular, the access to and the powers of reviewing tribunals. What requirements must be satisfied to appeal against a judgment, and the way in which the procedures before review tribunals take account of the fair and public hearing requirements of Paragraph 1 of Article 14. 18. Article 14, Paragraph 6, provides for compensation according to law in certain cases of a miscarriage of justice as described therein. It seems from many state reports that this right is often not observed or insufficiently guaranteed by domestic legislation. States should, where necessary, supplement their legislation in this area in order to bring it into line with the provisions of the Covenant. 19. In considering state reports, differing views have often been expressed as to the scope of Paragraph 7 of Article 14. Some states' parties have even felt the need to make reservations in relation to procedures for the resumption of criminal cases. It seems to the committee that most states' parties make a clear distinction between a resumption of a trial justified by exceptional circumstances and a retrial prohibited pursuant to the principle of ne bis in idem as contained in paragraph 7. This understanding of the meaning of ne bis in idem may encourage states' parties to reconsider their reservations to Article 14, paragraph 7.